Hello, welcome to CCHP's Telehealth 201, HIPAA and Privacy. These are introductory small short videos in order to provide you with a little bit more in-depth information about certain issues. And today we'll be talking about HIPAA and privacy and how that works with telehealth. A few disclaimers before we get started today. Please know that any information provided in today's talk is not to be regarded as legal advice. It is strictly for informational purposes. CCHP always recommends that you consult with legal counsel if you are interested in a formal legal opinion. Also know if I happen to mention a company or show a picture of some type of product, neither I nor CCHP has any type of relevant financial interest, arrangement, or affiliation with such a company. So what exactly is HIPAA? So HIPAA stands for the Health Insurance Portability and Accountability Act, acronym HIPAA. It's a federal law that passed Congress in 1996, and basically it offers national standards to protect the patient's medical records and other personal health information. It applies to health plans, healthcare clearinghouses, and healthcare providers, and it sets limits on what information can be disclosed without patient consent. And patients are given certain rights over their information, such as the right to examine and obtain records. So there is a link on the slide here, which if you download the PowerPoint, and we will make it available, you can click on, it'll take you to a government website, the HHS, Health and Human Services, where they have a little bit more detail and information on HIPAA itself. Now, a lot of questions we get is, how does this interact with telehealth? And know that the way HIPAA acts is that it essentially acts as a floor on protecting health information. Because not only do you need to consider what federal law does, you also need to consider state laws as well. And this is really important for telehealth providers because most healthcare providers, when they're not using telehealth, they're probably used to just basically dealing with one state. They're dealing with seeing patients in person, and they're dealing with those patients whose state laws that apply to them are the state that the provider themselves are located in. So they really don't have to think about what happens in other states. But if you are using telehealth, you are easily crossing state lines sometimes to provide services to patients in other states. And those states may have different types of health information and privacy laws. So keep in mind, HIPAA is federal law, so that is essentially your floor. That's sort of like the minimum of like what you're required to do. But states may have more detailed or more stringent policies around protecting health information, or they may have something that HIPAA itself doesn't cover. Now, what happens when you think you have a conflict between like following what state law does or what federal law does? Well, if it's on the same issue and the state law and the federal law conflict with each other, federal law usually triumphs. So if there is sort of like a state law that kind of contradicts what the federal law does, you're going to like follow federal law. But if there's a state law that is actually going further than what the federal law does, or if it's something that the federal law that HIPAA doesn't touch upon, the state law would be the one in place and what you have to pay attention to. An example of that is in California. So California has something called the California Confidentiality and Medical Information Act. And in some of the ways that they differ from HIPAA, where there may be a bit more stringent or extra requirements from the HIPAA law, is that the CMIA includes information about those that are required to abide by CMA as recipients of protected health information, which differs from HIPAA because HIPAA does not include recipients as a category. And also CMIA's definition of provider of healthcare is more extensive than what you see underneath HIPAA. So what you have here is a state law that sort of requires more of you or more protections or wider protections than what HIPAA does. So if you are providing services to patients in California, while HIPAA is your federal floor that you have to follow, keep in mind, California requires more things of you or have more stringent laws in place. And this could be the case in other states as well. So it's important for you to be like familiar with HIPAA, but also with the laws and regulations in the state that you're going to be providing services into. So what does this all mean for telehealth? There's the obligation to follow telehealth, to follow HIPAA and other privacy laws do not change just because you're providing services via telehealth. You're still going to have to abide by them, but you may need to think about things a little bit differently. So just because you are following the same laws doesn't mean that you are following the same protocols you might have in place when you're using telehealth, because those protocols may not actually allow you to meet with compliancy with those HIPAA laws or those state laws. So you may have to alter your thinking a little bit in like how you are trying to protect that information when you're doing it via telehealth. So, what are some of the ways that that can happen? For example, you may be, dealing with vendors who are providing a telehealth platform for you. And that's not a vendor that you're typically dealing with when you are providing services in person. You may need to get a business associate agreement with them. So that's sort of one thing about needing to think differently, like who you would need business associate agreements with. And also, again, be mindful of where you're practicing, because again, state laws vary in like how they address or protect that personal health information. I mentioned the business associate agreement, but there's also another example of like training for your staff. You may need to train staff who will need some training regarding like protecting health information and like certain protocols around that, who may not have needed that when you're providing services in person. So for example, maybe you have more tech staff in place because you're using telehealth now, and they'll need that training. And maybe they didn't need that if you were strictly a practice that were doing services in person. So these are a few things to keep in mind when you're talking about protecting personal health information, when you're talking about HIPAA and you're utilizing telehealth to provide those services. So for more information about CCHP, you can go to our website at cchpca.org. We also have a newsletter that you can subscribe to. And otherwise, thank you again for visiting us on this short policy informational video. Have a great day.